As a lawyer, I get a little nervous when I'm wired. So, my name's Glenn Stoddard. I want to thank Pilar and everybody else who organized this for inviting me and Ron and Curtis and Tom to be here tonight. Needless to say, and to make a poor pun or a bad pun, this is a hot issue, or you wouldn't all be here tonight on such a hot night. I know there's several of you here. In fact, some of you are my clients, and you probably are, at least some of you, aware that I've been doing, as Tom said, a lot of work on Frac-Sand mining lately as a lawyer. I'm a lawyer based in Eau Claire. I live in Hayward now, and I'm sorry to say that this year I've put about 22,000 miles on my car, driving to meetings all over the place. Many of them on this issue, town meetings, county meetings, county board of adjustment meetings, and so on. My practice, I started practicing law back in early 1995 after going back to law school as an adult, after having worked as a legislative aide and done some lobbying work with conservation and farm organizations. My background before law school was in urban and regional planning, environmental planning, and before that in natural resources management. And I wanted to go to law school to get involved in environmental and natural resources issues and also civil rights issues. Well, I've done that, and here I am still doing it. I started working on mining issues even before going back to law school in one of my early jobs for Washburn County, when metallic minerals were discovered in northern Wisconsin, and counties were concerned at that time. And I was working as an assistant zoning administrator for Washburn County, and we were worried about mining then. But I really got into mining issues in 1996, metallic mining issues with what was then the proposed Crandon mine, a large proposed copper zinc mine in northeastern Wisconsin. And I worked on that issue for the town of Nashville, and then also for the Mole Lake, Sakagan, Chippewa tribe, and was involved in quite a bit of litigation over that. Ultimately, that mine was stopped when the Mole Lake tribe and the Forest County Potawatomi tribe were able to acquire the rights, the mineral rights. But I've also worked on other metallic mining issues, the Ladysmith mine and the reclamation process the last few years. I was involved in that, and then I was involved more recently in working for the Bad River tribe in opposing legislation that would have allowed a large taconite mine to go in near Mellon. During that whole span of time, I also got involved in this whole issue of Frac-Sand mining, and my first client was Jerry Losted, who is here tonight, and we were concerned about mining and the destruction of Hoffman Hills. Shortly after that, or a year or so after that, I was hired by the town of Cooks Valley in Chippewa County to review a very simple ordinance that the town had adopted, and to revise it to make sure that it would stand up to legal challenge. Because at that time, this was in the fall of 2008, the town next door, where Ron is from, was seeing a proposed Frac-Sand development, and the town of Cooks Valley was very concerned about the same thing happening to Cooks Valley. Long story short, that ordinance was challenged initially, I should say. After the challenge, this is the Cooks Valley ordinance, it was thrown out by the circuit court. Appeals, were made after that by the town. Ultimately, the Court of Appeals did what we call punting and sent it up to the state Supreme Court. And earlier this year, on February 8th, the state Supreme Court came down with a decision actually reversing the circuit court and upholding that ordinance. It's a very short ordinance, 3 pages. If I were writing it today, it would look different than it does, but not a lot different, and I'll tell you why shortly. Having said that, we're all learning a lot about this whole issue. And I want to step back just for a minute and talk a little bit about the impacts. Mining, whether it's frac-sand mining, metallic mining, coal mining, carries with it some fairly obvious impacts if you think about it. Obviously, there's environmental impacts from disturbing the earth and changing the hydrogeology in the area, creating dust and so on. But there's also all the impacts that go with the processing, the transportation, the noise, the operations at the site, and so on. These are impacts that are not that different between different types of mining operations, whether it's a metallic mining operation or a non-metallic mining operation. What's different is the materials themselves can be different, and they have different implications for groundwater, for example, and surface water, as well as air. And then the intensity of the activity that's going on, or the operations themselves. And in Wisconsin, if you think about what we have traditionally considered non-metallic mining, we've thought about non-metallic mining primarily from the standpoint of gravel pits. Gravel pits or sand pits that every county and many towns, some private enterprises have in order to get materials for road construction and repair. And those non-metallic mining operations have been the context within which we've regulated through zoning ordinances adopted by counties and towns in some cases, and villages and others. And they've been the context within which zoning ordinances have dealt with this issue, meaning that the intensity of the use, the type of operation, has been generally considered to be fairly minimal. You know, it would be intermittent when these operations would be actually used and mined, mostly during construction operations on roads and so on. Frac-sand mining has introduced a whole new dimension to non-metallic mining in Wisconsin. It's much more like metallic mining or coal mining in other parts of the country. And I say that because it's an ongoing, very active, highly intensive type of land use. So there's not just this intermittent extraction of materials and then shipping, and then where the mine is no longer used. It tends to be, at least what we've seen so far, an ongoing industrial type operation. So it's much more of an industrial kind of land use, much more of an industrial type of business operation than the traditional non-metallic mines that we're used to thinking about in terms of gravel and sand operations. So the impacts involve noise, light. The road impacts that have been mentioned tonight are huge for towns and counties and for state roads, but especially for town roads because they're not engineered to deal with this kind of traffic, the heavy trucks and the volume of trucking. It's also a different operation in the sense that there's much more potential for dust and air pollution. The dust from silica sand is a major health concern for many people. You know, if you're handling it, it's clearly dangerous. What's unclear is how people in the broader community are affected, and we don't have a good handle on that, but that's a very serious concern, and at this point the state is not regulating it. And then you have water quality, surface and groundwater impacts from these operations. So you have many different nuisance type impacts that affect the site itself and the surrounding properties and the broader community. And they affect the public health and safety of people in the community, people who use the roads, people who breathe the air, people who depend on the water, have wells. And these impacts also affect the general welfare of the community. And when I say the general welfare of the community, I mean the quality of life and the property values and property interests, property rights of people who are living there when one of these operations comes in. Now, those terms that I just used are important. Public health, safety, and general welfare are the the words that are sort of magic words in the law when it comes to municipal regulation of virtually any kind of industrial operation, not just frac-sand mining. Those are the words, those are the terms that are used to describe what we call the police power under the law. And the police power is the power of the states, not the federal government, but the states, to regulate in order to protect the citizens by protecting their health, safety, and general welfare. The police power is handed down by state government to county and local units of government with many different variables involved. Zoning is based on the police power, and it is one component of the police power. But licensing is another component of the police power. Licensing can go beyond zoning. The ordinance in the town of Cooks Valley that we adopted there, actually, and that I helped revise, and that has been upheld now by the state Supreme Court, was based on the police power, but not on the zoning application of the police power. And that was done because the town of Cooks Valley was an unzoned town, and still is. Under state law in Wisconsin, towns, generally speaking, if they want to have zoning, usually go under county zoning. Now, there is an exception to that rule, and in certain situations, I won't go into the details of it right now, but if you're interested, we can talk about that. Towns can have their own zoning, but usually that has to be approved by the county board. In the case of Cooks Valley, the county board in Chippewa County was very pro frac-sand mining at that time. And for all I know, they still are. I don't know what their position would be today, frankly. But we knew that the town of Cooks Valley was not going to be able to get a zoning ordinance through the county board that was intended to regulate frac-sand mining. So when the town retained me to work on their ordinance, it was to develop something other than a zoning ordinance, and that's what we did. We kept it very simple. And basically what it says, in a nutshell, is that a company has to apply for a permit. The application is a fairly detailed application. It then goes to the Town Plan Commission for review and recommendation to the town board, and the town board then ultimately makes a decision and decides whether the proposed mining operation is in the best interest of the citizens of the town, and if it will protect the public health, safety, and general welfare of the citizens. And the ordinance also gives the town board the discretionary authority to impose conditions or to deny the permit altogether if public health, safety, and general welfare cannot be adequately protected. What's interesting in terms of Cooks Valley, and I use that as an example because it's what I've been most involved with, and I'm still representing the town, is during the time that the ordinance was struck down by the circuit court and before it was in effect reinstated and upheld by the state Supreme Court, which was a virtually unanimous decision. One of the justices sat out on it, Justice Prosser, but otherwise it was upheld pretty much unanimously by the rest of the court. What's important about that is that we developed the ordinance, and while it was ineffective because it was on appeal, 3 mining companies came into the town, acquired mining rights to properties, and started mining. And they are currently active. So now we are in the process, and I say we, I mean the town board, the town plan commission, myself as the town's attorney, are in the process of trying to regulate these 3 companies after the fact. And right now, I'm reasonably optimistic that we're going to be able to get permits in place later this year that will put some very, very sound and good restrictions on all 3 of these companies. But had the town board at the time in 2008 not been faced with an ordinance that was struck down by the local circuit court judge, they might have turned down these mines, and they would have had the right to do that. At least now we know that based on the Cooks Valley case. Now, when the state Supreme Court upheld this ordinance, it simply said this ordinance, the Cooks Valley ordinance, withstands a facial challenge under the police power. It didn't say this is a great ordinance. It didn't say it's a, an ideal ordinance, and I've never asserted that it was. It's a 3-page ordinance, and it's very, very generic. But the important point of this court decision is that it affirmed what we've thought all along, and that is that towns have the regulatory authority under the police power to regulate apart from zoning or in addition to zoning, as long as they have village powers. And village powers are something that towns can adopt, at their annual meeting or in a special meeting where there's a vote of the electors. Most towns currently have village powers. Not all do, but most do. And it's something that the Towns Association advises towns to get. So most of the towns that are contacting me these days have village powers and are interested in developing some sort of a licensing ordinance like either the town of Howard or the town of Cooks Valley or another town that may have an ordinance. Now, interestingly, before I got involved in working with Cooks Valley, I was working with some citizens who were concerned about a proposed trap rock mine over near Osceola. And that town had developed an ordinance that was very detailed, very, very long. And the same firm that challenged the Cooks Valley ordinance didn't even challenge that ordinance. But we were able to get the proposed trap rock mine stopped at the county level in a conditional use process. So towns have been regulating in this area with licensing ordinances for quite some time. It's just that the Cooks Valley case was the first case that went up to the state Supreme Court specifically challenging a non-metallic mining ordinance as being improper vis-a-vis zoning. So we're past that. One of the things, and I'm going to talk about some other regulatory issues here quickly, and then I'll try to sit down and let you ask questions, and we can take our break, and then I can deal with questions later too. And I don't want to overlap with Ron because I know he's got a lot of experience here and some different perspectives probably based on that experience than I do. But there's a few other things I do want to mention. First of all, though, I think it's important to point out that if towns don't have any regulation at all, you're dependent on the county if you have county zoning. And if you don't have county zoning, you're dependent on the county just for a reclamation plan and permit under what's called NR 135. Counties have to have reclamation ordinances. But those only deal with the reclamation of the mine. They do not deal with these other off-site impacts, impacts to roads, impacts to air, water, wells, noise, light, and so on. And you would be dependent on DNR to regulate air, but again, DNR is limited in what's happening there in terms of regulation. And you would be limited to what DNR is doing in terms of protecting wells. What we've found is that the state regulations implemented by DNR, air, water, and then the NR 135 reclamation plans, which are actually implemented by the counties, but under state law, only deal with very limited areas of impact from these operations. To protect your town roads, to protect air, to protect property values surrounding these sites, you really need to do something locally at the town level or through a county zoning process. What I'm recommending as a lawyer to town officials who contact me, even if they do have county zoning, and even if it does seem to regulate in this area, let's say for a conditional use process or require a rezoning to industrial, I'm still recommending that town boards, if they have village powers, adopt a licensing ordinance to regulate and to protect their own town. And there's a number of good reasons for that. One is to protect the town roads. Now, you don't have to have a licensing ordinance to do that. You can do a road agreement, and you can just regulate roads as a town without a licensing ordinance. But I think it's much better to try to do that as part of a licensing process if you can, or at least on a parallel permitting process. The other things to think about are the air, the water, the dust, the noise, the light. Those are all nuisance impacts that towns can regulate through a licensing ordinance. The county could do that through a conditional use process as well, but is less likely to. And so a licensing ordinance will give you that flexibility and that authority. Now, when you do this kind of regulation as a town, you have to act reasonably. So you have to have a good rationale for doing it. I mentioned the 3 pages of the Cooks Valley Ordinance. It does not specify in detail what these kinds of standards would be. That is left to the permitting process, where the town has to sit down with the applicant, look at what they're proposing to do, go through things like hours of operation, how many loads of, how many truckloads they're planning to have, what trucking routes they're proposing, what they're going to do to control dust, noise, light, what they're going to do to monitor wells and groundwater in the area, and so on. But what we're doing in Cooks Valley is we're laying all those details out in the permitting process, and it's kind of like a negotiation back and forth process that we're going through with the mining companies. Which brings me to another point. Another option that towns have, and I don't want to steal Ron's thunder because he's been involved in this more than I have, but towns can go through an agreement process, can develop a mining agreement with Frac-Sand companies in lieu of or instead of a permitting process. And there are some legal differences that are important to be aware of. There's pros and cons on both sides of that. You can still do it, a town can still do an agreement if it has a licensing ordinance, and it actually, in my opinion, should have a licensing ordinance if it's going to do an agreement. Some lawyers may disagree with me on that, but I think at least the lawyers that I've been working with in representing towns, and there aren't very many, most of them are on the other side, agree with me on that. It tends to be the lawyers on the other side that think a town can do an agreement without having any kind of an ordinance in place. If you're in town government, you have really nothing to lose by putting an ordinance in place. Now, what do you do if you're trying to develop an ordinance and you're looking at 5 different examples and they're all different? And I can guarantee you they are. Every one of them is different. And I just talked to somebody last night about this from a town in Monroe County, and they asked me, and I said, honestly, if I were drafting an ordinance today, it would look different than it did a month ago, because this whole thing is evolving, and we're learning. We're getting new information about what the companies are doing in their mines, what kind of chemicals they're using. We're getting new information about the state of the technology and so on. But what's really important, in my opinion, is to have an ordinance. And it's not as important to be hung up on making it incredibly detailed as it is to make sure that it's at least sufficient, as the simple Cooks Valley Ordinance was, to stand up to a facial challenge. And then the second thing that's really important is that if you do get a mining company coming in and applying for a permit, then you have to treat that mining company and any other mining company or property owner fairly and reasonably in the process. But having said that, every one of these operations is going to be a little different, if for no other reason than because of the location. That creates differences in terms of traffic patterns and everything else. So it's perfectly appropriate to regulate on a case-by-case basis. But in doing so, on those matters that are comparable or essentially similar to what would be regulated in another location, for example, lighting requirements or noise requirements, you better be consistent. Now, you might be inconsistent if you're dealing with the trucking routes, the traffic patterns. For example, let's say you're regulating a mine that wants to do 500 trucks, wants to have 500 trucks hauling sand a day. That's actually 1,000 trips, okay? If they want to go past or through a village, that's a very different situation than if you're regulating a very similar mine that doesn't go through a village at all. Or if they want to go near a school, it's a very different situation. So you can look at those things, and you should look at those things differently on a case-by-case basis. What some towns are doing, and I think the Towns Association is recommending this, and I fully agree with it, for towns that are thinking about regulating and aren't sure what they want to do, what ordinance they want to use as a model, and they need time, maybe they've got a citizens committee put together to develop an ordinance, what they can do is adopt a moratorium. The moratorium is a form of an ordinance. The town needs to have the village powers to do that, but it can essentially can freeze any development of frac sand mining in the town for a limited period of time. Most lawyers that I know would recommend keeping it a very short period of time, 6 months, 2 years max. So you could go 6 months, extend it out another 6 months while you're developing the ordinance, but don't put it in place and think you're just going to leave it there. You've got to be working on something or it's going to be challenged. Road agreements, I mentioned, that can be done as part of an ordinance, but it can be done separately. It's very important in my judgment, and we've done this in Cooks Valley, other towns have been doing this as well, to lay out the routes, make sure you have very clear conditions on alternate routes, if there's repairs that need to be done, and so on. And there's models out there for road agreements. Let me just talk briefly about property values. If you think about a mining operation coming in to your neighborhood and all of a sudden creating noise, light, dust, truck traffic, it's going to change the quality of life, and that, in effect, is going to be capitalized into nearby property values. You didn't move to the nuisance moved to you if you live there. And all of a sudden, you have property, if you live near a mine, that's much less desirable to any potential buyer than it would have been before, especially in this beautiful, western Wisconsin area with our hills. It's not the same as moving next to an airport and then finding out that the airport is going to add in an additional landing pad. That's a different scenario altogether. You move into an area like this, and now a frac sand mine is coming in, all this operation is going on. It's pretty obvious that it's going to have an effect on the desirability of your property and ultimately on the value of the property. What we, and I say this generically, are doing in this area is working with these companies to guarantee property values of surrounding properties. And Ron can probably talk about this because he was one of the first to negotiate this with a company in the town of Howard. So I won't go into it too much, but I can tell you that what we're doing in Cooks Valley right now with the 3 companies that are there is we are proposing to them, and we're taking a pretty strong position on it, that they need to guarantee the property values of properties within a half mile of the exterior boundaries of the mine. I also personally think that if there's a trucking route along town roads and the town gives a company a license to use those roads, and it has, because of that, traffic is going to have an effect on properties along the roads, that's something that ought to be fair game as well. But, we haven't actually gotten to that point, and I don't think we will in Cooks Valley because of the specifics involved with these 3 mines. It's a little controversial as to whether or not you can regulate through a permitting process to protect property values with a property value guarantee. I've talked to some lawyers who think that you can only do that with an agreement. I disagree because the police power has been construed by the state Supreme Court as protecting property values under the general welfare clause. in a zoning context, going back to I think it's the 1950s, there's a case. But if you can get agreement with a company to protect property values, that's always going to be better than if you're trying to impose it on a company. So if you're a town official, my advice is whether you go a permitting process or an agreement process, you want to get a dialogue going, you want to work with a company, you want to call them on their promises, which are almost universally thrown out at public meetings, that they want to be good neighbors. You want to say, okay, let's put that in writing. You want to be good neighbors, let's protect the property values of your neighbors. And that way, if they can't sell their property for a price that's reasonable based on what it would have been without the mining operation, you're going to guarantee it as a mining company. And this is called, in the law, we talk about it in law and economics, we talk about it as internalizing the externalities. Mining companies coming in, they're profiting off of this operation. It's not economically reasonable for them to be able to profit at the expense of other people, because then the profits aren't really real economic profits. The costs should be built in. The same theory applies with pollution. If a company can pollute, and this is why we have companies going to third world countries where they can pollute with impunity, it lowers their cost of production. But it's artificial lowering of the cost of production because it puts those costs on the people who have the health problems from the pollution. In this case, the property losses. Anyway, this is a complicated area, but we're developing a pretty good set of ordinances out there that towns can look at and work from. We're developing permits and agreements that can be used as models, and there's no reason for a town to sit back and wait. If you do that, you run the risk of having a mining company come in and then you're trying to catch up. And it's much harder to catch up after the fact, which we're having to do in Cooks Valley, than it is to have something in place beforehand. I should say this. I mentioned this is a hot topic. A year ago, it's my understanding there were about 50 Frac-Sand mines in the state of Wisconsin. This year, I understand there's about 100. It's doubled. And that's already developed. There's more going on all the time. But it is a boom-bust industry. And just to give you an example, Frac-Sand, as you may know, is used for fracking, hydraulic fracturing for natural gas and oil. The type of sand that's used for natural gas tends to be a smaller grain, finer grain sand than it is for oil. Hydraulic fracturing has been so successful to date in the natural gas area that there's actually a surplus of natural gas. Consequently, the demand for the frac sand used in natural gas has actually kind of settled down a bit. That's not the case yet, anyway, for oil. But depending on where you are and what kind of frac sand is being extracted from your area, that could be a factor. So you can't depend on this company coming in and necessarily being there for 30 years as they say they're going to be when they start, because the market could change things dramatically. And that happens with all types of mining. Anyway, I've gone beyond my time. I apologize. I'll take any questions you have, but I'll wait around too if you want to ask questions later. Thank you.
Thanks, Glenn. I do want to, we are running a little bit late, and I really think that what Glenn said and what Ron said fit together really well, and I know Ron's hands-on experience with towns is really important. So here, bear with me, I'd maybe one question now, I'd do a quick break, come back up, and I have a hand over here already. So, and then we'll come back up and we can hear from Ron, and then we'll ask both of them questions.
We have 30-some quarries, sand and gravel pits in the county, and we were told at a recent town meeting that we should pretty much assume, and this is by an operator, we should pretty much assume all of them are being tested for frac sand. Now, we saw one very easily apply for an expansion and get it, and I think it didn't involve a rezone. If there was a public hearing, I missed it. It was very quick and easy, just expansion approval. How can we best assure that our county won't become riddled with Frac-Sand mines at all the sites of these gravel pits? Is there a way to regulate at the county level, at the town level? Through what process? Using definitions, using sizes? What's your recommendation?
Well, I think at the town level, I think you need a licensing ordinance, and you need to make sure that the definition is encompassing of that type of operation being expanded. Now, for example, in Cooks Valley, a pre-existing operation that doesn't require a permit under NR 135, a reclamation permit, would not be covered by the ordinance. But if it's expanded, then it would be. And it sounds to me like what you're referring to is a situation where you have small pits that now they're being tested, and now they're probably going to be expanded if they have suitable frac sand. If the county's allowing that to go on, well, it's too late to deal with the county. You need to have something done at the town level to regulate that. One thing I should say, that good thing about a licensing approach like Cooks Valley has and Howard has and other towns have been developing is that there's no grandfathering in of pre-existing mines. You're regulating the operation itself, and you can regulate that even if they're already in place. That's not the same as in zoning. Zoning has a whole doctrine of non-conforming uses and grandfathering that generally would apply unless there's a real expansion. So I would just say, get your town to put a licensing ordinance in place. It doesn't have to be a complicated ordinance. It can be a fairly straightforward ordinance, or it can be more complicated. It's really up to the town board how far they want to go with it.
Okay, why don't we take a 10-minute break? 10 minutes at the most. Get some refreshments, and then we'll come back up and finish up. These are information that was presented at the conference last winter, I think, right, that you referred to, Pilar?
Right.
Why don't you?
This is from the Wisconsin Department of Revenue's presentation at the Wisconsin Towns Association Frac-Sand Conference. It was held January in Eau Claire. And this was the slide I was trying to remember that was part of the original presentation. And I just found it very helpful as a former elected official to make sense of, I think the information that Curtis had presented us with was really helpful in terms of characterizing the types of investments that might or might not be taxable or exempt. But I found this slide really helpful in terms of summarizing, even though it's a very big, wide-ranging estimate, that you're talking about potentially 8 to 20% of the total cost being taxable portion. And I just found that helpful because back of the napkin math, gives you a little bit more of a sense than someone just coming in and saying it's $60 million. Now, it has been pointed out that every single project is different and has to be estimated line by a professional assessor to know. But the other thing I thought was really helpful was noting that most equipment depreciates according to this slide. Now, I heard a different estimate from Curtis, I think, but using a 10-year life depreciation index. And if I understand that correctly, it means that even if you start with $1 million, it's going to go down by $100,000 and then a little less than $100,000. So 5 years into it, you're going to have about half of that value as your tax base. So this slide is available as part of the Wisconsin Towns Association. If you guys picked up the handouts that were available downstairs, there's a color printout of the Wisconsin Towns Association website. And that page that you're seeing is the link. If you click on Education tab and then click on Frac-Sand, this particular presentation is available through the WTA website. And you can click through it yourself if you find it helpful. Page 17 of 37. Thanks.